For better or worse, that's how the human mind works. Once you start putting a name to the animal, once you start telling how much you love your dog, you're introducing prejudice into the equation, and that's the difference. That's why this is so prejudicial.
All rise.
Probably 16 now, so that's not what's been presiding.
Please be seated.
All right, good morning. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, and we'll move to the defense.
Kemp, Pepperman, and
Teddy Parker.
Good morning, Your Honor. Jim Neale, Mr. Nick Hoffman, Mr. David Spurlock on behalf of the UNFI.
Good morning, Your Honor. Bill Odou on behalf of Real Water.
Morning, Your Honor. Scott Rasmussen on behalf of the Hanna Instruments.
Morning, Your Honor. Jim Cavanaugh, Gordon Reeves, former third-party defendant, Real Water of Tennessee.
Your Honor, Rob Robbins is not in the courtroom right now. He asked me to go ahead and get started. I'll be able to take care of whatever happens.
Oh, yeah, and that's fine. I understand Mr. Robbins is pretty busy. But did we cover all appearances? Did we get Mr. Spurlock?
Yes, sir. Yes, sir.
Okay,
I hope I didn't forget him.
I just want to make sure. Anyway, I apologize for the brief delay, but I had to go down and swear in your pool and make sure they fill out the questionnaires appropriately, and that takes time. And I'll be candid with you, I think that should happen in every case involving a jury questionnaire, because really they become part of the panel at that point. They need to be sworn in. I make sure they understand that they have to fill out the questionnaire completely. They have to be truthful and forthright in all their responses and all those types of things. Just as important too, I do give them the recess admonishment. I explain that to them. And for anyone that's appeared that's ever tried a case in my department, I also read the letter from the vet. I do that. And the reason why I think that's important, and it's a letter that I read in every case. It's from Mr. Devon Rice. And I think I got that letter as a result of the...
He was in the HMO case, Your Honor.
Yes, exactly. And it's a great letter. It really and truly is. It's a combat vet. And I do that to let them know, and so they understand the process and they take it serious. Okay, but anyway, we'll move on from that.
The third part is when he's talking about going down the riverboat and dealing with the troops
Oh, yeah,
and
yes.
fighting for the country. And then
It's
he comes
very
back,
compelling.
Here's all the jurors whining about it.
Right.
That's my favorite part.
Well, I think what it is, there's nothing convenient about a great democracy, to make sure they understand that. Right? But getting back to some of the issues at hand, and I thought about it, and I went back and read some cases. I actually went well beyond what I discussed yesterday, and I mean, took a lot. I did like maybe an informal survey going back to Shoshone Coca-Cola bottling company versus Delinsky, which is a 1966 case, right? And I think that's probably one of the seminal cases as far as straight products liability is concerned in the state of Nevada. But if you go back and read the case, it has some great language, and I think, and understand this dealt with both the manufacturer and distributor. And the reason why I think it's important to point out, as we've gone through this case, and there's been argument regarding motions, issues that have come up regarding potential conduct, and I always come back and focus on, wait, the focus should be on the product and whether the product is in a defective condition, unreasonably dangerous, pursuant to the restatement of torts 402A. Now, this is what our Nevada Supreme Court said, and we're going to talk about a couple cases here. And this is Shoshone. I think this is at page 442, give or take, maybe 441. And this is what our Nevada Supreme Court said at that time, and I think it's really important to really focus on some of the language. They say, quote, "We affirm the verdict and judgment since, in our view, public policy demands that one who places upon the market a bottled beverage in a dangerous condition, in a condition dangerous for use, must be held strictly liable to the ultimate user for injuries resulting from such use, although the seller has exercised all reasonable care and the user has not entered into a contractual relationship with him. They go further, and they say perhaps the supporting policy reasons are best expressed by William L. Prosser in his article, The Fall of the Citadel. And that's 50, Minnesota Law Review 791, 799, 1966. And this is taken straight out of the Law Review article. The public interest in human safety requires the maximum possible protection for the users of the product. And those able to afford it are the suppliers of the channel. By placing their goods upon the market, the suppliers represent to the public that they are suitable and safe for use. And by packaging, advertising, and otherwise, they do everything they can do to induce that belief. The middleman is no more than a conduit, a mere mechanical device through which the thing is to reach the ultimate user. The supplier has invited and solicited the use, and when it leads to disaster, he should not be permitted to avoid responsibility by saying he made no contact with the consumer or that he used all reasonable care, period, close quote. I mean, I feel that's very powerful language. And the reason why I pointed it out, and this is important to remember, since 1966, Nevada has not deviated from that in any respect. They haven't, because we'll get to a 2017 case. And then we kind of move on, and that's not the first time our Nevada Supreme Court didn't go back and look at the fall of the Citadel, because it came up again, right? Once again, and we're going here. So we're approximately 28 years later, right? And it's revisited again, and this is in the Allison versus Merck case. That's 110 Nevada, 762, 1994 case. And this is what our Nevada Supreme Court set forth. And I think it's really just mirrors what they said in the Shoshone case. And this is at 769. They say, unless we are going to abandon longstanding public policy grounds for holding manufacturers and distributors of defective products responsible for injuries caused by the manufactured products that proved to be defective, Thomas must be given an opportunity to prove that a malfunctioning vaccine causes injuries, just as we allowed Ms. Stakowitz to try and prove that her injuries were caused by a defective steering mechanism. But this is where they talk about public policy again. They said the public policy considerations that support holding the defendants liable in this case, if plaintiffs can prove the vaccine caused his injuries, were well put by Professor Prosser. Once again, right? And they go into and they cite fall of the Citadel. And they take the same language that was set forth in the Shoshone case back in 1966, and this is straight out of the case, and they say, quote, the public interest in human safety requires the maximum possible protection for the users of the product, and those best able to afford it are the suppliers of the channel. By placing their goods upon the market, the suppliers represent to the public that they are suitable and safe for use. And by packaging, advertising, and otherwise, they do everything they can to induce that belief. Exact same language. Straight out of the Citadel. Going back to Professor Prosser's law review article at the University of Minnesota Law School, right? But the journey continues on, and I think this is really very, very important, because we go to 2017, and we have the Ford Motor Company case versus Trejo. And the reason why I think this is important, because I think we're really putting everything into context, right? And there's significant public policy, because this is all public policy based. It really and truly is. And it doesn't seem to me that our Nevada Supreme Court has stepped away in any respect as far as what we ultimately want to do. We want product safety for the end user, the consumer. And this is and understand this is an important case because they rejected the restatement third approach as far as the risk utility analysis, right? And this is where Nevada Supreme Court said as far as that's concerned. They said, quote, this court is not persuaded that the third restatement risk utility analysis provides a superior framework for analyzing claims of design defect. Rather, the risk utility analysis inserts negligence standards into claims of design defect, contrary to public policy, supporting the adoption of strict products liability in Nevada. And at the end of the day, they ultimately, as far as Nevada law is concerned, have been steadfast. As far as here in this state, the thrust and focus is on the product, not the conduct of the parties, not what they did or didn't do, and so on and so on. A defective product can reasonably be dangerous. And that's why we've had all these discussions, and I've always come back to, what do we hear for a defective product can reasonably be dangerous? And they go further, and they talk about alternative designs, and I get it. But they said, this is what they say, the requirement that the plaintiff must provide proof of a reasonable alternative design is not supported by Nevada law and poses an unfair burden to many prospective plaintiffs. Therefore, a claim of design defect in Nevada will continue to be governed by the consumer expectation test. I mean, and this is, what is that, 5 years ago? Something like that, 2017?
Yes, sure, I think.
6 years maybe, yeah,
Justice-
6 years ago, give or take.
That was Justice Stiglitz's first major opinion.
Yes, and they go on and they say, I want to make sure this is clear. Accordingly, we conclude that the district court did not err in declining to give Ford's proposed jury instruction on risk utility test. And here's my point, and I understand what the distributor's position is in this case, and it appears to me they're focusing on some of their conduct. That's not relevant. You know, and basically, and you know, when you look at a distributor, there's certain things a distributor could do as it pertains to distributing products, as it pertains to manufacture. But I don't really think that's really germane in this regard, because at the end of the day, strict products liability. That's what it's all about, you know. And so my point is this, and I'm going to get to the issues at hand, because I understand there's issues regarding prior notice of potential defects and issues regarding prior causation. I have a comment on the causation component because I can see where potentially that could be misleading because we're just focusing on the product defect aspect of it. And it's not the same as medical causation. It's not, really and truly. Because I think it's important not to go down that road, because here's why. The other matters as it relates to causation, they're not making a claim for damages in this case. They're not a plaintiff to this case, right? And that's kind of being overlooked or overshadowed. Of course, if they were, we would go back to Las Vegas Medical Center versus Perez or whatever those cases are. We all know what it is. If they're making a claim, of course, they have to prove it based upon medical evidence and the like. But the law is much different because remember this, it's maximum protection for the consumer. That's Nevada. And just as important, we might talk about other states, but I think Nevada law is pretty well developed as it pertains to the consumer expectation test and what's appropriate here. And so we understand we have issues regarding notice and the causation issues. There's issues regarding, and I don't mind saying it, I looked at some of the cases, they're letting a lot of things in, right? And so the question is, not whether that's, and they didn't have many trials on every issue that came in. They didn't do that. It would come in for purposes of notice, you know? And here's the thing, and I think in this case, what the distributor saying is, well, Judge, you know, we weren't part of this, you know? We weren't the manufacturer. Okay, but you're the distributor. There's joint and several liability, right? If it's a defective product, you're on the hook. And if you think maybe you're on the hook and you're on the hook wrongfully, well, you got contribution and indemnity, maybe contractual, maybe equitable. I don't know. But that's not the thrust of what the decision is. And so what I'm going to do is this, regarding the notice issue, I'm denying the motion. Those things can come in. And it's the same thing on the causation issue. If there's a true issue, maybe you need more medical records, because remember this, it's coming in just as it relates to allegations of a defective product, right? And I'm gonna go back to Shoshone and tell you why I'm ruling the way I'm doing, because what Nevada appeared to me from a public policy perspective, that, let me make sure I get this line correct.
Judge, that would be a denial of both 10A and 10B?
Yes, sir. And this is where Nevada Supreme Court said the public interest in human safety requires the maximum public possible protection. That's what Nevada law says, right? And just as important, I don't want to get into issues regarding necessarily conduct as far as the distributor is concerned, because the thrust and focus should be on the product. Is it effective or not? And that'll be my decision. And we can move on to the next issue.
Your Honor, just before we move on, we did join in that particular motion as we discussed your final comments on that yesterday, with it. There probably has to be a different standard for liability with regard to the meter folks in this case, so.
Well, no.
You don't think so?
No, not necessarily a different standard of liability, it's straight products liability. I think, and you can correct me if I'm wrong, I think the theories deal with marketing of the product and the fact that when this product was being marketed, there was no warnings or anything like that regarding the uses of the product, and should it be used for alkaline water manufacturing. I mean, I don't know, we haven't got there yet,
Okay.
but that's kind of what I was thinking we're going.
Yeah, it's the same product liability law, Your Honor.
Yeah, it's the same product, yeah.
Different product.
It's a different product, that's the point, is that we have a different product. I assume that when this stuff comes in about, you know, one of their clients that's not a part of this case, their emails are gonna come in. It's not about my product.
Oh, well, I mean, we're not there yet, but I think it's being alleged as a component in the manufacturing process.
That's by their choice, by Real Water's choice, we would say you don't even need it for their product. So
But I think, and I don't wanna
we'll get
speak for
there.
anyone, we'll get there, but I think it dealt with marketing aspects, warnings.
It's a different product, Your Honor, and the problem is, we have to prove that it's a really dangerous product with regards to real water.
Right.
We have to prove that. We have to prove that it caused the plaintiff's injuries. In addition, we've got to go a little farther with regards to the meter, and prove that that was a defective product, either designed
For its
defective
purpose,
or
right?
failure to warn.
Yeah, I understand.
And in addition, prove that that was a proximate cause of the injuries.
Right.
Okay, that's what we have to do. But with regards to the first point, proving that it's, the water's a defective product, the notice comes in for everybody because it goes to the product. It doesn't go to, it's not defendant-specific notice, as the court too.
I understand.
Okay, I think I understand what the court's going with this. We'll prepare and have we already have our motion on file.
Oh, yeah.
We'll be heard later on.
Yeah, we'll deal with that later.
Thank you.
You're welcome. So where do we go now?
We're on 11, Your Honor, and I think that ruling resolves pretty much all 11, but I'll leave it up to counsel.
Your Honor, Nicholas Hoffman for UNFW. So UNFW's motion eliminating number 11 is to exclude references to non-liver injuries of non-Gallagher plaintiffs. So those are the individuals or pets.
And when you say non-Gallagher plaintiffs, what do you mean by that?
That means anyone outside of these 7 individuals before your honor.
What
And,
about for notice of causation issues?
well, this is it's a little bit different. So this is specific to non-liver injuries, and I'll explain why that's a little bit different too. So, obviously the allegations in this case are liver injuries. The Southern Nevada Health District found it was an outbreak of acute non-viral hepatitis. Plaintiffs have phrased it as liver failure injuries. And what we have in the complaint, which I think Your Honor saw briefly yesterday, are pretty widespread, far-reaching allegations at some points that, just frankly, there's been no evidence disclosed or produced by plaintiffs on some of these things. And I believe the first part of this motion is actually uncontested. So the first part has to do with humans who have non-liver injuries and who are not in this case. So if Mr. Stevens, you could pull up the second amended complaint and go to paragraph 58 first. And again, Your Honor, I believe this is the portion that, according to plaintiff's opposition at page 12, is uncontested. So at 58, you'll see here, there's a reference to at least 70 other persons that suffered severe liver damage have already filed suits, including 1 death case, 2 liver transplant cases, 1 brain surgery case, multiple miscarriages, and then, a bunch of people in the ICU, this says. And, we brought this motion with regard to the brain surgery, the miscarriages, and the unspecified ICU stays. And the reason why we're bringing it for those is because there has been no evidence of those. We don't know what those are even referencing. In their opposition, plaintiffs do say that they believe the brain injury is something that was suffered by a plaintiff Strong in the Bonner case, and again, my client's not in that case. And they say that I don't think they actually, they do identify 1 miscarriage by someone else in the Bonner case, it appears, but again, my client's not in that. And as I said, it appears that plaintiffs have stipulated to that portion of the MIL. So for the brain surgery, the miscarriages, and I believe the ICUs, although I won't speak for Mr. Kemp on that, but I'll let him respond when he gets up. I believe that portion is uncontested. The second part of this motion, the contested portion, has to do with dogs and cats. So plaintiffs want to introduce various evidence about alleged incidents where dogs or cats were sick from drinking real water. All of this information is either highly speculative and or hearsay. There has been no evidence from any veterinarian. There is no medical records from any dog. I'm going to give you an example here, which is the testimony of Jeffrey Desautels. And to set this up, essentially what happens, and what we've seen in this case, is plaintiff's counsel or their paralegal call witnesses and discuss with them the case, and then they're asking these kind of retrospective questions about, did you ever have an injury? Did your dog ever have an injury? Or plaintiff's counsel will ask it during depositions. And there's various times where witnesses speculate and say, oh yeah, my dog was a little lethargic, or my dog had this or that, and without any sort of admissible evidence, they say, oh yeah, it might have been real water. It's possibly, I don't know, I never thought of it that way, but possibly it was real water. So I'm going to play for you the testimony of Jeffrey Desautels as an example of that.
2000s, miniature.
Do they have any problems?
Yeah, they both died.
And with what frequency would you feed the Dachshunds for real water?
Oh, every day?
When you talking 2016 through 2020?
Yes.
But you saw the lethargy problem more often.
A little, yes.
After you got the real water.
A little bit more, yes.
Okay.
Never thought of it to be water.
And how about Sassy?
Sassy unfortunately drowned herself in the pool.
But you thought that they had illnesses related to real water?
Sassy, I can't say, but Missy, definitely something, I can say one of them did die of older age, based on what the vet told me.
In your mind, it's a potential that Missy died sooner because of real water.
It could have, yes, potentially. I'm not saying it is.
So Your Honor, that's an example. There's another example that's in plaintiff's opposition at page 12 of Casey Aiken, who, Casey Aiken is a Real Water former employee, and he essentially says that his dog was lethargic. He took the dog to the vet, and his wife or his veterinarian said that he might have had some sort of liver issue, so he gave him pills. And, the ending testimony, which I'm sure plaintiffs will show you, this is again on, this is on page 13 of their opposition, I apologize. The ending testimony is, you said the vet diagnosed a liver problem, the answer yes. And so, again, there's nothing admissible here on any sort of dog or cat who was sick from Real Water. Everything that has been heard is all hearsay. There's no medical record that's been produced. There's not a single expert in this case who has said that there's been a dog or cat sick. And in fact, none of the plaintiffs in this case are claiming that they had any sort of dog or cat that became ill due to Real Water. So it really has no relevance here. Obviously, there's also very serious substantial similarity issues with dogs and cats versus humans. There's not a single case that we've been able to find, or the plaintiffs have cited, where incidents involving another animal could be used to try to show anything against the human. So, causation, defect, notice, or any of it. Obviously, as Your Honor said yesterday, that you're a big animal lover. I'm a big animal lover. I have a dog, 10 years old, and he's reached the time where, unfortunately, sometimes he's throwing up frequently, or he has illnesses, eats something at the mall. There's just no telling what is the cause of that, and so there's no way that that should be introduced to prejudice defendants. And obviously, with animal lovers like you and like me, we know how impactful that would be. That would be unduly prejudicial to have some hypothetical, speculative testimony about an injury to a dog or cat that is completely unverified. And in fact, Your Honor, the FDA, CDC, and Southern Nevada Health District investigated all the dog and cats that any of the owners thought might have become ill due to Real Water. And they were not able to find any conclusive evidence of that. So, for instance, they did a necropsy of a cat who had passed away, and they found no causative evidence in that necropsy. So there was no sort of toxic agent. They did not find a single thing that would have conclusively shown that that cat became ill because of Real Water. So, Your Honor, as I said, there's no evidence before the court, and we do not think that evidence relating to animals is in any way admissible with regard to humans. And I give the example again. A dog slips down the steps outside the courthouse. Is that notice of something for a human a month later? Is that causation for a human? It's just not. There's no substantial similarity at all that would satisfy the burden for Andrews versus Harley Davidson. In that case, the court goes through, and that's 106 Nevada 533. The court goes through the analysis, and this is at pin site 538 to 539. The court goes through and says whether the jury may be allowed to draw an inference as to the defectiveness of a product from product failures depends on whether the factors which produced the prior failures were substantially similar to the factors which produced the present failure. And this goes right to the issue of causation or defect that Your Honor is focused on. And the court then went through the analysis and said that it was admitting evidence from another deposition because both men had similar injuries. They both testified that their injuries occurred when they were thrown against the gas tank of their motorcycles after it separated from the frame. That both men drove into the back of a car while traveling around 30 miles per hour. That both men's motorcycle had an identical frame, engine, and fuel system, and that the differences in their accidents were trivial and would have little to no effect on their injuries. That's the analysis that the Nevada Supreme Court has laid out for substantial similarity. Going through that analysis here, first off, it's not even possible to do the analysis because we don't have any other information about these dogs or cats. We don't know how much water they were drinking, what their ultimate diagnosis was. We don't have any medical records. We have no expert testimony. But if you did try to go through with the information that we have, you certainly would not reach a conclusion that there's substantial similarity or that the differences in the incidents are trivial. There's just simply nothing that would connect any of these hearsay statements about dogs or cats to the plaintiffs in this case. So, Your Honor, and I'm certainly not going to re-argue 10A or 10B or your honors comments this morning. But if this is coming in for causation, we would just note, and if it's coming in for causation for any defendant here, Real Water, UNFW, any defendant, that it cannot be based off of hearsay evidence. It has to be based off admissible evidence. And, I won't go back over the authorities for that. I went over them yesterday. But if it's coming in for causation, it has to be admissible evidence. And there is no admissible evidence here of any dog or cat illness. It's all hearsay or multiple levels of hearsay or speculative, as we saw with Mr. Desitel. And one other comment on the notice versus causation / defect issue is that if something comes in against Real Water for strict liability, we agree that would be admissible for strict liability based off joint and several liability for UNFW. But if it comes in for notice against Real Water, that's only coming in for negligence. So obviously that would not be then admissible against UNFW. So there is that distinction where the evidence has to be cabined for the purpose that it's being used. So if it's coming in for causation / defect, yes, we agree, that would be admissible for UNFW. If it's coming in for notice as to a different defendant, such as Real Water, that would not be usable against UNFW, and we would request a limited instruction on that, for the reasons that I've stated previously. Finally, just for a complete record, Your Honor, this type of evidence is not admissible against UNFW for notice. I understand, Your Honor, that you commented that this would come in for causation on these other ones, but just for the sake of a complete record, for notice here, the Belsky and Haley instances of them purchasing alleged retail bottles occurred in 2018 and 2019. They were hospitalized in May 2018 and September 2019, respectively. Casey Aiken's testimony about his dog said that his dog became ill in October 2020, which obviously would be subsequent to the dates that Mr. Belsky and Mr. Haley became ill. Again, as Your Honor knows, those are the only two plaintiffs who have alleged anything against UNFW in this case. Those dog instances, such as Casey Aiken, would not be admissible against UNFW for notice. As for causation, if Your Honor finds that they are admissible for causation, we would just ask Your Honor what the admissible non-hearsay evidence is, or what the hearsay exception is for that evidence. And I would note that the Trejo case that Your Honor cited does cite approvingly the Guinness versus Mapes case, and that is the case also that discusses substantial similarity, and it does say, Your Honor is absolutely correct, the Guinness case does say that a plaintiff has a right in a strict liability action to introduce evidence of a substantially similar accident to prove that the design of the product involved in the accident is defective. And so in a strict liability, the issue is that causation / defect issue, but of course, you cannot use inadmissible hearsay to prove that. So, Your Honor, just to sum up, in any event, we do believe that this evidence of the dogs and cats would be unduly prejudicial against all of the defendants here. There is no admissible evidence of any of these dogs or cats becoming ill. It's all highly speculative. We also don't believe that any of this evidence is admissible for the issue of notice against UNFW. And if it's coming in for causation, it needs to be supported by admissible non-hearsay evidence or hearsay within a valid exception. And if it's coming in for a specific purpose, it needs to be cabined to that purpose. So if it's coming in for notice, it needs to be cabined to just notice against that defendant. It cannot be used across the various causes of action. So if something comes in for notice on negligence, it cannot be used across for strict liability. A limiting structure should be good. So with that, Your Honor, I'm happy to answer any questions, but otherwise I'll yield the floor.
Thank you, sir. I don't have any questions at this time.
Your Honor, Joel Odou on behalf of Real Water, very briefly, we joined this motion. I think the court saw in Mr. Desitel's case how emotional people are about their animals. I am too, and how prejudice outweighs any probative nature. The court also commented the other day on a number of pet food recalls. That happens all the time, and to say that these dogs were made ill by Real Water is absolute speculation, and it's not probative to any issue in this case. It's just so prejudicial. People are so emotional about their pets. We don't know what a juror is going to do about that.
We're just to put on the record, I'm also joining this motion, that's all.
Thank you, sir. First of all,
after saying he wasn't gonna try to re-argue the previous motion, Mr. Hoffman did, and said, Judge, we should go back to the notice for defendant kind of approach as opposed to the notice of the product approach. It's a notice of the product, a notice of potential and dangerous defective condition of the product. That goes to UNFI, that goes to everybody who's involved in the case. So the argument that there should be some sort of limiting instruction on these is inappropriate because they're a distributor. Same notice to the product for the product they distributed as it is to real water. It's not a dependent notice situation. Point two, in the motion, and they filed a lot of motions about these prior instances. I'm assuming we're not talking about the customer complaints now because you didn't bring them up.
No, we're gonna wait for that one, we'll do that one
Okay,
after.
fine, that's 14. All right, Your Honor, so this motion addresses 4 different things. One, the brain surgery and the miscarriage. We have 2 clients, Mrs. Strong, after she drank real water, they had to rush her down to San Diego, and she's got veterans benefits, so they took her to La Jolla. They did extensive brain surgery on her because one of the problems with hydrazine is it creates ammonia in the brain. And there's a lot of literature about that, but she's one of the plaintiffs in the case. I have agreed to leave that out of the case because I just don't want to get into the brain surgery aspect at this time. So we've agreed with their motion with regards to Mrs. Strong. We won't mention that. The second point is Mrs. Strong's daughter, Mrs. Gassius. She drank real water. They went up to Red Rock, they went hiking, they took a bunch of real water with them, they drank it. And, one had brain surgery. Mrs. Gassius had a miscarriage as a result of this. We've also agreed not to bring that up in this trial. Okay, so we have agreed to that. The third thing he mentioned was just ICUs in general. We are not agreeing to ICUs in general because most of the people with acute liver injury went to the intensive care unit first. So by just focusing on the ICUs, that would suck up all of the acute liver injury cases. So we are not agreeing to that for any case, including the Wren case. Okay, they haven't discussed any specific case other than the Wren case, but we are not agreeing to that with regard to any other case. So that, and again, if someone has acute liver injury and they drink real water, that's admissible as notice of potential defect and dangerous condition. Moving to the animal cases. If you recall, and I think we touched upon it briefly, they've conceded general causation. They have conceded that hydrazine can cause acute liver injury. Okay, that is a concession that their experts made, their toxicologist, Dr. Kostenbach makes it, Dr. Dar makes it. Everybody concedes that hydrazine can cause acute liver injury. There's a debate as to the amount of the hydrazine that can cause acute liver injury. But they have conceded that hydrazine causes acute liver injury. What is that concession based upon? That is based upon the science that hydrazine can cause acute liver injury. Specifically, it's based on animal testing. The Air Force was using hydrazine for rocket fuel, so they did an extensive series of tests, like the Air Force sometimes does, Your Honor, in the 60s and 70s, where they fed hydrazine to almost every dog species known to man, and they use the term sacrifice the animal after the test. Basically, they just fed them hydrazine, they killed these animals. But that is what the causation, the general causation opinions are all based upon. So there's no dispute that hydrazine causes injury to humans, and there's definitely, we can't do tests on humans feeding them hydrazine, well, other than this case. But we can't do tests on humans to feed them hydrazine. But they did do it on dogs. So it is an established proposition that hydrazine causes liver injury and other injury, but let's focus on liver injury in dogs. So now let's look at the evidence in this case. First, we have Mr. Desitel, who I will remind the court was the Quality Assurance Director of Real Water in the 2017-2018 timeframe. It was his job to investigate customer complaints, all right? He's testified, and you saw a little clip of it, there's a lot more. He's testified that he fed his own dogs the real water, and that one of those 2 dogs died, and he attributed it to the real water. That's what he testified to. He is the Quality Assurance Director. The second person is Mr. Akins. Do we have that testimony, Chris? This is Mr. Akins' testimony. And again, he's the one that made the super bad batch sometime in the first or second week of October. So he makes the super bad batch. He calls up Blaine Jones. So he fed his dogs water from this super bad batch. That's where this water came from. Did you ever have any problem with the dog after you fed it the water? Yes. What problem was that? I took him to the vet because he was sick. He got sick. I didn't know what he was from. His wife's a vet tech, a technician at the veterinarian clinic. So she said, don't give your dog the water. Didn't know what it was. That's the only thing they changed. They stopped giving the water. The dog got better. Then we go on a little further. Takes him to the vet. He's puking. Vomiting is a pretty common symptom in hydrogen toxicity case. Vomiting, lethargic, and the vet, Casey Akins' vet, diagnosed it as a liver problem. Okay, what better proof could you have that the super bad batch he was making, and that super bad batch we think went to the U plaintiff, the Arnone plaintiff, the Bottiz plaintiff, and maybe the Ryerson plaintiff. But anyway, plaintiffs in this case drank this exact same batch of water that he fed to his dog that caused the dog to get sick and vomit. Now, I'm not trying to bring in all the dog cases because there's dozens of dogs that people fed real water to and they start vomiting. How do I know that? Can we have the core report, please? This is the FDA's core report. This has been admitted already? Yeah, this is an admitted document, Your Honor. Can we have the page on the animals, please? Okay, so the FDA, in conjunction with the Southern Bad Health District and the CDC, came in. This is an admitted exhibit, Your Honor. 14 dogs and 1 cat were reported by consumers as exposed to real water. 11 dogs fully recovered, 3 dogs and 1 cat died. That's coming in right now. That's an admitted exhibit right now. 3 cats and 1 cat, 3 dogs and 1 cat died. Yeah, they didn't do autopsies on the dead dogs, okay? There is an actual case in litigation that's actually one of the next cases occurred, Your Honor, where the vet did do an autopsy on the dead dog. But we're not seeking to read that into this case, though. But this is an admitted exhibit. The 3 dogs and 1 cat have died, according to the FDA, from drinking real water. So the question is, in addition to this evidence, should we be allowed to put in Mr. Desitel's dog and also Mr. Akins' dog? Okay, I think Mr. Akins' dog, how can there be any question about that? That's an animal that drank from the super bad batch. Mr. Desitel's dog, I thought Mr. Desitel's testimony was pretty discerning because he said 1 dog he thought died in real water and the other dog he said died in a swimming pool. Okay, so it's just 1 dog in that case. And again, he's the quality assurance director of real water. He's an employee of defendant. So to suggest that the quality assurance director is feeding his dog real water and the dog dies, and that's not relevant, it ain't even trying. Those are the reasons that we think we should be allowed to introduce just these 2 dog cases. Like I said, other than the FDA finding I'm not intending to introduce, the 3-year-old golden retriever up in Boulder City that died in the prime of its life from drinking real water. I'm not trying to get that in. I'm not trying to get the, I get my dogs wrong. There were 2, it was a tragic case. It's another plaintiff's case. She fed her two dogs that have been longtime dogs with water. They both died. I'm not trying to get that into this case. All I want to do is get in Mr. Desitel's dog and Mr. Akins' dog. I understand.
Nicholas Hoffman for UNFW, and I'll try to be brief. Mr. Kemp said that he pointed kind of generally in this direction, so I don't know if he's referring to my client or real water. but he said that,
He's probably referring to everybody. but-
Probably. He said someone had conceded general causation, and to be clear, my client has not conceded general causation. So there is a disputed issue here, and, I understand that he's making an argument about Dr. Goldsmith and his impact on causation, but there's a disputed issue here whether, the amount of toxin, quote unquote, or hydrazine that was in any of this water could cause any sort of injury. That's general causation. And, I won't bore you with specific causation because we've all briefed that now and you have those bench briefs that you can go through. But those get into more, with regard to Mr. Haley and Mr. Belsky, whether they actually, for instance, drank that amount of water. But so, Your Honor, just to be clear, my client has not conceded general causation. And there's certainly no evidence in this case about general causation with regard to dogs or cats. So there's no expert testimony here about hydrazine at any level causing any sort of issue with dogs or cats. So, Your Honor, under any standard, including...
Was that an FDA report?
that was a CDC core report, and I would note, and I was going to get to this, I would note 2 lines under what Mr. Kemp showed you. It said, quote, cause of death undetermined. And we saw what Mr. Kemp did with that document. He took the document, cause of death undetermined, and said, here's all these cats and dogs, they all died from drinking real water. And that's what he's obviously going to do at trial, and that's what this MIL, the second portion of it, is all about. That is unduly prejudicial. We need to have a clear instruction, at very least, to Mr. Kemp that he is not allowed to take this document that says cause of death undetermined and that did not conclude that these dogs and cats died from real water, and be able to tell the jury that it's somehow proving that. That is going to completely prejudice all of the defendants here.
Can I see that report? I have so much on my desk.
Pop that back up, Chris.
Thanks, Chris.
Your Honor, you see it says 14 dogs and 1 cat were reported by consumers as exposed to real water. That's reported by consumers, nothing the CDC is doing. 11 dogs fully recovered, 3 dogs and 1 cat died. The cat was reported negative for rabies, SARS-CoV-2, no obvious hepatopathies, negative for microcystins, and cause of death undetermined. The one they actually looked into, this is the CDC, and this is what I mentioned in my opening argument. The one they looked into and they actually analyzed was this cat. They did a full necropsy on him, and that cause of death was undetermined. They did not find any evidence of a toxin there. So there is no evidence from CDC that real water, or FDA, or Southern Nevada Health District, that real water caused any sort of issue, let alone a liver injury.
How do I interpret this? It says a total of 20 probable and 5 suspect cases were reported with illnesses onset dates ranging from 8/19/2020 and 11/29/2020.
Those are talking about humans, Your Honor. So those are, at that time, there were 20 probable. It ended up being 21 probable cases. And I believe the 5 suspect, I might be wrong on this, but I think it did end up at 5. And those are the approximate date ranges that the CDC, FDA, and Southern Nevada Health District found. So, Your Honor is going to see testimony from the epidemiologist that you've heard a lot about already in passing, but you're going to hear testimony from the epidemiologist from the Southern Nevada Health District about these probable and suspect cases, and she's going to explain.
Here's a question I have for you, and because I thought about this, and understand this, I understand medical causation, but the standards are slightly different as it pertains to strict products liability. And I'm looking at it through this lens, and we have, for example, we have the testimony from Mr. Akins regarding his dog. We have also testimony from is it Mr. Desatow and his dog?
Yes, Desatow.
Right, and so, and this is why I think it's important to point out. It's not like they're making claims for damages as a result of these events, right? That's a much different standard, but we're focusing on the standard as it pertains to products liability law. And so when I look at it through that lens, for example, and remember this, and this is another, and I don't mind telling you this is the things I think about. I mean, we have direct evidence, we have circumstantial evidence, we have Mr. Aiken's testimony, we have Mr. Desentol's testimony. We have exposure, sickness, times, et cetera, et cetera. Why isn't that germane?
Well, Your Honor, to be clear, the causation analysis does not change for strict product liability, so you still have to prove causation.
No. I'm not talking about, like, for example, in any tort case, for example, the plaintiffs are going to have to prove medical causation. We understand what that is. But this is going to potentially notice and or causation vis-a-vis strict products liability.
Well, so
Other events, you know, that's kind of where I'm going.
So, Your Honor, to be clear, so for the notice analysis, that is for negligence specifically. We went over that yesterday, and I think Your Honor has recognized that. And so for
No, I
Shoshone,
have. For the
Okay.
record, I want to make sure that,
Okay.
please, you know, put words in my mouth.
okay, so for Shoshone, which Your Honor discussed today, Trejo and the other cases in that line of cases, those are strict liability cases.
I
And
understand that. That's why I keep coming back to.
Yes.
And there's discussions, well, we're just a distributor. Well, that doesn't matter in a strict products liability case. We can all agree to that.
yes, we can agree to that, Your Honor. So Shoshone, Trejo, those are strict liability cases. And for the other incident cases that relate to strict liability, that's Andrews versus Harley Davidson, and that's Guinness versus Mapes. Both of those talk about the other incident evidence in relation to strict liability, and both of them say that it's coming in for causation/defect, not for notice.
Okay, but I come back to causation/defect.
Yes.
And it's not like those other incidences are coming in, and I agree with that analysis, but it's not the same time, and tell me if I'm missing something here, right? Because I don't mind vetting this issue, but it seems to me it's not like a morsicato or a type issue. It's a different issue. It's going to focusing on whether there was a defective product, unreasonably dangerous. It's not causation as it relates to proving up medical specials, injury causation, and those types of things. Now, if I'm wrong, you can tell me that, and trust me, I don't mind that.
Your Honor, respectfully, and I don't want to say you're wrong, but on the notice equation, the reason for all this case law, and this is across the country, but including Nevada, the reason the notice equation can include hearsay other incidents is because in the negligence cause of action, obviously duty and notice, so the awareness, are relevant. For strict liability, the duty and the awareness, the knowledge, is not in that cause of action. So that's why there's this distinction across the board, across the country, where stuff that comes in for notice, it's not going to a claim for causation. So basically what plaintiffs are trying to get Your Honor to do is to admit something for notice because it's a lesser standard, and you can use hearsay, and then to apply it to the causation analysis for strict product liability. That's what all the case law says you can't do, and we're happy to prove that, Your Honor.
What did the Nevada Supreme Court do in Robinson?
So in Robinson, I think that, if I remember correctly.
That was the supermarket box boy case, and he was operating the box crushing machine.
Yes. And so that was admitted for the negligence claim, I believe, and that's why it's my understanding for
I thought this was straight out of the case. Robinson tried to offer evidence at trial of other accidents that occurred with similar commercial machines to show that the enterprises knew of the danger the machine posed. This court has recognized that prior and subsequent accidents are admissible in an action based on strict liability.
yes. And I do have it now in front of me here, and it's citing back to Guinness, and Guinness explains that for strict product liability, that's coming in for causation/defect.
What did it come in for in Robinson?
So in Robinson, my understanding, I just have it here in front of me, I haven't reviewed that section fully this moment, but it's coming in for showing alternative, safer fabrics.
Robinson fabric? I thought it was a machine, no?
No,
Yeah, it says
Robinson is coming in for a quote to show a defective, a dangerous condition, one, and causation too.
That's actually referring to Guinness, I believe, and Guinness is saying we held that evidence of prior and subsequent repair orders.
But I mean, can't the Nevada Supreme Court kind of, as they get new issues, because which I would anticipate, tell me if I'm wrong or not, Robinson's a newer case.
Yes.
Yes, you're right.
Newer than Guinness, but not.
Yeah. But I mean, but as issues come up, they can expand, they can contract, whatever. And the reason why I bring that up, and that's why, to me, I felt this was very powerful. At the end of the day, I looked at some of the other cases, I don't mind telling you this. I always circle back to Nevada. I think this is very much overlooked. Nevada tort laws doesn't necessarily follow California, they don't follow Utah, they don't, I mean, Nevada is kind of, and I think it was Justice Stiglitz kind of said it best. And as she went back, I mean, if you look back going to Shoshone in the 60s, all the way up to 2017, when it comes to strict products liability, the ultimate concern is maximum protection for the end user, the consumer. Isn't that what that case law says? And they're citing Professor Prosser from University of Minnesota Law School and those types of things.
Yes, Your Honor, I have Robinson here in front of me, and I don't think it's clear that it came in for negligence respectfully. I mean, I see here the citation to Guinness, and it does state, as Your Honor stated with Shoshone, that the other incidents for prior and subsequent accidents are admissible for dangerous condition and causation, or to show defective and dangerous condition and causation, and that's at, I know Your Honor has it in front of you, but that's at 140. And regardless of that,
Okay.
the thing that we would emphasize is that if something is coming in for notice, which is hearsay, it has to be cabined to negligence, because that is the claim it's being used for. What matters is the purpose for which that evidence is being offered. And that's straight out of Guinness, direct quote from Guinness. It's citing to Witkin from California, but that's straight out of Guinness. If it's coming in to show duty, and if this defendant who heard
I mean,
something.
there's a duty. I don't need to come in for duty. There's a duty. You put the product in the stream of commerce, you have an end user. There's a duty as it relates to whether or not it's a dangerous condition.
You are absolutely correct, Your Honor. So that's why the duty analysis and the notice analysis is not relevant to strict
I don't have to do
liability.
with duty analysis. I mean, if they're an end user, there's no product misuse or any of those types of things, right? They just consume water.
Your Honor, what I'm trying to explain is that you are absolutely correct. There is no duty analysis or notice analysis for strict product liability. So the hearsay evidence, such as Jeffrey Desatel and Casey Aiken, cannot come in for causation or defect unless there's a valid hearsay exception. Now, the one thing that I would like to do, if Your Honor will indulge me, is to replay Mr. Desatel's testimony, because Mr. Kemp.
This is a high stakes game. And I don't mean game, but it's a high stakes case.
Yes.
I'm gonna let you do what you have to do. I'm not gonna cut you off. I guarantee you that.
Thank you, Your Honor. And I want to replay it because Mr. Kemp, I don't think it was intentional, but misrepresented the final conclusion there from Mr. Desatel. The final conclusion from Mr. Desatel, which we're going to play for you, Your Honor, was, quote, when Mr. Kemp is trying to get him to say that it was caused by real water, for the one that didn't drown in the pool, this is the other one, that died of old age, according to the veterinarian. The quote is, it could have, yes, potential. I'm not saying it is. He's not even saying that it was caused by real water, but Mr. Kemp now is going to try to take that and say to the jury that he is saying it, just as he did to Your Honor a few moments ago. So with that, Mr. Stevens, if you play it once more. And obviously, Your Honor, as he gets that ready, I mean, this doesn't satisfy Williams, this doesn't satisfy any standard.
But that's
even.
my point. We're trying to conflate causation standards, right? These people don't have a claim for bodily injury.
Well,
If we're talking about causation as it relates to a defective product, we're not talking about medical causation as it pertains to a claim for injuries related to a motor vehicle accident and lumbar injuries to the spine.
so Your Honor, before we play that then, let me address that. So that analysis does need to happen. So this is straight out of Andrews versus Harley Davidson, 106 Nevada, 538. So it explains that a jury for the causation analysis, if something's coming in for causation or defect, coming in to prove a defective product, that there needs to be substantial similarity with the prior failure versus the failure alleged in the case. And the reason why that's so important.
That's
and there's-
totally different than a medical causation analysis. That's not the same analysis.
So I'm getting to that, Your Honor. So all of the case law explains that you have to compare the cause of the prior incident versus the alleged cause in the case. And the reason why that's so important, and there's actually a lot of case law explaining that there's a heightened standard for similarity when you're using it for causation versus notice. And that's because you are inviting the jury to infer based off of a prior incident that that same cause in that one caused the incident before the court, before the jury. And so because of that, you do need to compare the cause of each of them. And here, the fundamental flaw that we have with Mr. Kemp's argument is we don't have any established cause or even anything that's admissible for any of these dogs or cats. Even the CDC, FDA, and Southern Nevada Health District, as you saw, said it was undetermined. They didn't say that there were dogs and cats that had injuries caused by real water. No one here has said that there's dogs and cats that had injuries caused by real water, other than Mr. Kemp and other hearsay inadmissible evidence. For instance, Casey Aiken was saying something about what his vet supposedly said. So, Your Honor, there is no evidence about the causation of those prior incidents that could even be compared to the causation in this case to invite the jury to do something that is literally inferring causation based off of inadmissible testimony. So with that, I'd ask Mr. Stevens to play Jeffrey Desitel one more time to see if he has actually established causation in that prior incident.
2 Dachshunds, miniature.
Did they have any problems?
Yeah, they both died.
And with what frequency would you feed the Dachshunds the real water?
Oh, every day?
Are we talking 2016 through 2020?
Yes.
That you saw the lethargy problem more often?
A little, yes.
After you fed them the real water?
A little bit more, yes. Water.
And how about Sassy?
Sassy unfortunately drowned herself in the pool.
But you thought that they had illnesses related to real water?
Can't say.
I can't say, but Missy, definitely something, I can say one of them did die of older age, based on what the vet told me.
In your mind, it's a potential that Missy died sooner because of the real water.
It could have, yes, potential. I'm not saying it is.
I mean, even Mr. Desitel himself said it's potential. He couldn't say it is. He says he can't say what the cause was. There is no case law supporting the introduction of this type of evidence for causation to allow a jury to infer based off of this that for humans, much less for other dogs, that the real water caused some injuries. There's no causation has even been established from Mr. Desitel to allow a jury to infer. So, Your Honor, I'm happy to answer any questions. We do believe that this goes directly against the case law both in Nevada and across the country for other incidents. We would invite other briefing on it. Again, if Your Honor is inclined to deny this motion, we would again request a limited instruction. We do think this is highly prejudicial and that it should not be admitted under any circumstances, especially against UNFI. Thank you.
Here's my question, and it does appear to me that if you take a look at Robinson, that 1991 case, our Nevada Supreme Court, when it talked about, it said, we held that the evidence of prior and subsequent repair orders and subsequent accidents involving the same door were admissible to show defective and dangerous condition and causation.
So, Your Honor, I think that
That's me straight out of the case. I'm reading it right here.
One distinction I'll point out for that case, for Your Honor, and I forgot to say this earlier, and I apologize for that, I did mention this yesterday, is the hearsay issue is not in this case. So that those repair orders were from the defendant, and it was the defendant's, my understanding, the defendant's own repair orders. So the hearsay was not an issue, so they skipped over that and went to relevancy. The problem here, and I have a chart on this later that I'm going to show Your Honor, but the problem here is that when you're trying to use something for a specific purpose, for notice, yes, hearsay can come in. If you're using it for causation defect, hearsay cannot come in. It has to be actual admissible evidence. And here, essentially what plaintiffs are trying to do is get something under the lesser standard for notice, use hearsay. Casey Aiken saying something his vet told him.
But no, he's not saying, that's not the issue. The issue is he unfortunately, one thing we try to do is dedicated dog owners, we want to make sure our dogs have fresh water all the time.
I agree.
And so he gave his dog real water, and apparently within a reasonable period of time, his dog started suffering symptoms as a result of the ingestion of real water. And he testified to that. And so, and he's a employee
Employee of real water.
of real water.
Solves
And
the
so,
same problem.
can we all agree on this one fact, that his testimony regarding giving his dog real water, circumstantial evidence, the dog becomes sick, he takes to the vet. That's basically what happened. So that wouldn't be hearsay. His testimony regarding what happened to his dog, right?
I think that would be fair. What about testimony about what the vet is saying?
We're making some ground here. That would be fair. And then I look at that and I couple that with which report was that again? That
Core
was-
report, Your Honor, that's a
The core
CDC report.
The CDC
And-
report, and they have, and here's the thing, and I kind of get it as far as these cases are concerned. And I don't mind telling you why I went back to 1966 or whatever the time period was as it pertained to the Shoshone case, because our Nevada Supreme Court truly articulated why they were adopting the restatement second of torts 402A and the public policies behind that. And I think that gets often overlooked, because what we're trying to do is dice away why our Nevada Supreme Court has been steadfast on one issue. And let me go back to Shoshone, quote, and this is straight out of the Fall of the Citadel, Minnesota, University of Minnesota Law Review, 1966. The public interest in human safety requires the maximum possible protection for the user of the product, and those best able to afford it are the suppliers of the check, close quote. And so, and what I found insightful from that, I don't mind saying it, is Nevada law has been consistent from 1966 to the present, as far as that's concerned. And the reason for it is this: there's public policy reasons for that. And I don't profess to be Professor Prosser, we all know what impact he played as far as torture is concerned.
Yes, Your Honor. Your Honor, if I could, I'm going to follow on with your question and your reasoning. And so you asked me about Casey Aiken and his observations, and from a hearsay perspective, his observation, I agree.
I mean,
But then-
he's direct testimony.
Oh,
He's
yeah.
talking about, I gave my dog water, my dog got sick, right, then he took him to the vet. And here's my point, and that's why I keep coming back to this. Everyone throws this causation issue out here. And there's different types of causation, right? And it appears to me this causation that's being argued by plaintiff's counsel deals with the defect itself. We're not necessarily dealing with medical causation. That's a different animal. And trust me, I understand that. I understand what Nevada case law is to a reasonably good medical probability. I get that. Provo versus Las Vegas Medical Center. And all those cases back in the 70s, 60s, going all the way up through Williams and so on and so on. We had it in, we had medical causation issues in KTVO and all these cases. And it just so happens that some of them I was a trial judge in, right? And I made causation rulings, and our Supreme Court kind of thought I was okay on it.
So, Your Honor, if I could go back to your line of thinking for Casey Aiken, and you're talking about hearsay, we're setting aside the substantial similarity issue, dogs versus humans and whatnot, but for Casey Aiken, we then get to the veterinarian supposedly telling him about some sort of diagnosis. That is hearsay. There is no evidence of that. There's no medical records. I mean, plaintiffs will tell you they don't have any expert testimony on that. There's nothing. They haven't introduced anything to that. That is quintessential hearsay. And so, obviously, no matter what, we think that needs to be precluded. And for Jeffrey Desitel, setting aside again the substantial similarity, which is the relevancy issue, everything that he's saying is speculative. He did not even say that he believes that it was caused by real water. He said, possibly, I can't really say. So how could that possibly come in to prove and have Mr. Kemp stand up and say, oh yeah, the real water caused it, when the guy himself is not even saying that it did cause it? And for the CDC.
Well, I think what he's saying is this, he says, I don't know for sure, but do I just ignore circumstantial evidence as far as that's concerned?
Your Honor, we do not believe that it's circumstantial evidence. This was, 4 or 5 years later, and he's now retroactively with a plaintiff's counsel saying, oh, don't you think that this person who died, the circumstantial evidence from him is that his veterinarian diagnosed the dog of dying from old age. That's what he testifies? And now.
The circumstantial evidence, I guess it depends on how you pick and choose, but from what I've heard, and based upon the testimony, his dog was doing okay, and then he started giving his dog real water, and the dog got sick, right? And then apparently he stopped, and the dog got better, or died of old age. I forget, I kind of mix them up, Mr. Akins and is it Desitel?
Yeah, Desitel. Desitel had 2 dogs. One died drowning in the pool, and then the other one died of old age, and the veterinarian diagnosed it with dying of old age, and when Mr. Kemp prodded him to say that it was caused by real water, he said, quote, it could have, yes, potential. I'm not saying it is, end quote. So he himself is not even saying that it was caused by real water. There's absolutely no reason that Mr. Kemp should be able to stand up and get the jury to infer that when this dog owner himself is saying, quote, I'm not saying it is, that Mr. Kemp is now going to say it is on his behalf and try to prejudice all the defendants here. And then lastly, Your Honor, following along your line of reasoning for the hearsay issue and the speculation issue, we've spoken about Casey Aiken saying his own observations, and if Your Honor finds that substantially similar and you want to, if that's for relevance, we do think that, okay, he's going to say his own personal observations for hearsay. But his statements about the vet are hearsay.
No, I think you're missing it. I understand the vet statement potentially could be hearsay. I get that.
Yes.
We don't have to argue very different. That's pretty straightforward.
Thank you. I appreciate that. And for Desitel, obviously, when he's saying, I'm not saying it is, and I'll go on from that, the CDC also said there was no conclusive evidence. They said the cause of death undetermined. They did not say that they did say that some individuals reported dogs and cats, but there's not a single sentence in that court report or anything that's admissible that says the CDC, FDA, or Southern Nevada Health District concluded that real water could cause injuries to dogs and cats, much less that that was somehow relevant to humans. So, Your Honor, there is no evidence of that. We would strongly urge Your Honor to consider excluding this, particularly on the basis of how unduly prejudicial it is. We all agree here.
Do I have copies of the court report, that one page?
You do, Your Honor. I don't know about in connection with this MIL, but we can certainly print one out and have it for you at lunch.
Just print it out to me, so I can make a decision. I want to see it.
No problem.
Because they take it up and take it down. I'd like to see it.
No problem. So Your Honor, based off the unduly prejudicial nature of this evidence, we would
I
ask Your Honor.
understand that too. Okay.
Yeah, we would ask Your Honor to exclude it. Obviously, what Mr. Kemp has done before Your Honor would unduly prejudice our clients before this jury, who don't have the benefit of having all these explanations. And by the time that they get it, I think unfortunately that the worms are a little bit out of the can on that one. So, Your Honor, we would ask this to be excluded. If not, we strongly urge Your Honor to give us a limited instruction.
We had Mr. Odou, sir.
I'll be very, very brief, Your Honor, and the distinction that we want to draw the court's attention to and why the court report is different is very simple. Mr. Desitel becomes very emotional when talking about Sassy and Missy. The court report has unnamed dogs. For better or worse, that's how the human mind works. Once you start putting a name to the animal, once you start telling how much you love your dog, you're introducing prejudice into the equation, and that's the difference. That's why this is so prejudicial, and is outweighed by any probative nature that it should be excluded for both Mr. Aiken and Mr. Desitel's dogs.
Okay.
I just wanted to point out
I
that
agree. It's too prejudicial.
Mr. Rasmussen, I'm never going to overlook you.
I know that, Your Honor.
The test under the case law is notice of potential dangerous condition. Counsel admitted that Mr. Desitel used the term potential That evidence fits so squarely within notice of potential dangerous condition that it's hard to imagine that it wouldn't. So for those reasons, like I said, we've already conceded, Gossius and
Oh, yeah,
Strong.
no, I mean, as far as, and I want to make sure I understand this, I just got the, it's conceded as far as the brain surgery case is concerned.
And miscarriages, Your Honor.
And the miscarriage, right, that's conceded too. So, that would be.
For this case only.
So those are out. And I guess the issue I gotta, because I would like to just kind of see the report, I understand what his testimony is and contemplate, I'll get a decision today, so we're not gonna kick the can down the road very far. But I would like to just read the report, so I have context.
And Judge, can we give you pages 2, 3, and 4 of Dr. Cosnet, our toxicologist report, where he talks at length about the animal studies proving that?
Absolutely,
Okay.
absolutely. That's gonna be part of the evidence, and, because I do have some circumstantial evidentiary questions, right? And maybe that'll address that. But you can give it to me, let's go to lunch. What do you think?
Yeah, that's good.
We agree.
And what is it now, 12:10?
So 13.
12:13? Okay, we'll come back at 1:30.
Thank you.
All right.
The what?
The people.
All right.
Department 16 now, come back forward.
Slow down. Okay.
Please be seated.
All right, good afternoon, and let's go ahead and set forth our appearances. We'll start first with the plaintiff, then we'll move to the defense.
We'll count for Eric Pepperman and City Parker.
Good afternoon, Your Honor, Jim Neale, Nick Hoffman, and David Spurlock for defending the UNFI.
Good afternoon, Your Honor, Joel Odou for the real water entities.
Good afternoon, Your Honor. Scott Rasmussen on behalf of Hanna Instruments.
Afternoon, Your Honor, Jim Kavanaugh, Gordon Reese, third-party defendant, Real Water of Tennessee, LLC.
Good afternoon, Your Honor, Rob Robbins from Milwaukee Instruments.
All right, does that cover all appearances? Okay, and what's the next issue up?
Your Honor, that's UNFW's motion to eliminate number 12.
Before we get to that, I just want to make sure we have clarity as far as, what are you getting to me as far as, I know Mr. Kemp said something from his expert, and you said something else there?
You asked for the core report, and
Okay.
I was not able to print that out during lunch, but we will get that for Your Honor. That's on our list.
Because I thought about that, and I understand what the issues are as far as the statements, the testimony of the two employees of Real Water. And I think, I really think that, and I know there was a place I got this from, but I remember reading the Ford Motor Company case last night. And I think Justice Stiglitz hit on some very important points as it pertained to the consumer expectation test and analysis. And this is what she says here. And the reason I'm putting this on the record, because this will ultimately be part of my decision. And she says this, and this is that page. I can find it, let me see here. I guess 656 or 529.
So what case was this, Your Honor, one more time?
This is Ford Motor Company. This is the 2017 Nevada Supreme Court case.
Got it.
And remember I asked you questions regarding circumstantial evidence?
Yes.
She addressed it in this case. Did you know that, or?
I didn't know exactly on what you're referencing,
Okay.
but I'm
Well,
excited to hear
I
it.
think it's important to put on the record. This is what she says, quote, "In addition to this departure from the policy supporting consumer expectation analysis," because remember we were talking about the consumer expectation test. Nevada said, look, from 1966 up until now, this is what we're going to do. And I talked about the policy behind that. But this is what, she actually has a fairly forward-thinking analysis. She says, quote, "In addition to this departure from the policy supporting consumer expectation analysis, we note that by requiring plaintiff to demonstrate proof of a reasonable alternative design risk utility approach actually imposes a higher bar for recovery than that in a case involving the standard negligence claim. the antithesis of adopting strict products liability in the first place. But then she goes further. She said, in addition to the inherent inequity in imposing an additional element of proof beyond negligence, this requirement presents several practical dilemmas. She said, first, the requirement that plaintiff present evidence that a reasonable alternative design presents a prohibitive barrier to the entry for many plaintiffs. As noted by the Connecticut Supreme Court, this would require a plaintiff to retain an expert witness even in cases in which lay jurors can infer a design defect from circumstantial evidence. And that's what she said. And so here we're talking about issues regarding potential notice or causation as it pertains to product defect. And my question was, okay, I realize there's no vet that's done this or that, but here we have two real water employees, and especially one said, look, my dog was doing okay until I gave him real water. And the dog became sick. And so on. And so I was looking at it from a, that's why I kept asking the question about circumstantial evidence, right?
Yes, Your Honor, I think if that satisfies the substantial similarity analysis in your mind, that comment from him about his observations would be okay under hearsay considerations, but not the other stuff for hearsay.
Yeah, but there's a reason why I brought that up. That's all I'm trying to say.
Understood.
And so what do I do with that? I mean, that's what she said.
So, Your Honor, from our perspective, that's a little bit different than the hearsay and the substantial similarity analysis that's the subject of the motion. So, you know, in order for it to be circumstantial evidence, it has to be admissible evidence. And so, you know.
But we're not talking about hearsay, right? Because that's testimony. I'm not talking about with the vet. I'm talking about his observations, his dog getting sick and so on.
So the only one that applies to then, that Your Honor just referenced and you limited the scope there, that's just Mr. Aiken saying that he specifically observed his dog after giving him real water and, you know, that he saw him become more lethargic or whatnot. And, you know, yes, that is a personal observation, so I don't think the hearsay issue is as important there. So the issue there is the substantial similarity. And if Your Honor finds that there's enough similarity between this instance with a dog, you know, supposedly, you know, drinking real water.
And I'm not making that decision yet. That's why I need to see the report.
Yes, yes. And if Your Honor makes that decision on if there's enough sufficient similarity between a dog drinking it and becoming lethargic compared to the plaintiff's allegations in this case, and, you know, that there's no problem with, you know, comparing dogs to humans, and that if Your Honor is satisfied that the causation issue with that dog is sufficient, then, you know, I guess that would be the decision. We obviously think that there's multiple issues that need to be parsed out because the vet obviously is hearsay. The CDC never said that they concluded anything with regard to dogs, so there's no causation there that could be linked or compared for similarity compared to these plaintiff's allegations.
I understand.
And then with Mr. Desitel, obviously, I think it's pretty clear from his testimony that it says possibly, but he's not even claiming that. So we don't think that could be compared. But we do completely understand Your Honor's comments about circumstantial evidence, and, you know, I think if hearsay is satisfied and substantial similarity is satisfied, then, you know, then you get to circumstantial evidence.
Right, and I guess that's what I need to see. What is the report, Mr. Kemp?
Core report.
Core report, okay.
It's a CDC report. I thought we had it in our binders, but unfortunately I couldn't find it. I'll look again during the next break.
Your Honor, and it is Exhibit 4 to plaintiff's motion eliminate number 1, and we submitted an appendix with the 4 exhibits, I believe. If it's more convenient, you know, of course, it's not a problem.
I have everything.
It was also in your pre-admission.
Yes, it was attached to our,
I
as an
wanted this
appendix.
whole couple of minutes.
You said Exhibit 4, plaintiff's motion limited number 1?
Yes, but we filed it, because of the volume, we filed it in a separate appendix
Okay.
of exhibits in support attached to motion eliminate number 1. So I believe we submitted a binder with the appendix. So if you have it, you may already have it.
I think we might have it in a binder. I could definitely look during the break if it's not easily found.
And we can, I guess we can proceed. Let me make sure. Which number again are we on, sir?
We are on UNFW's motion eliminating number 12. It's to exclude speculative evidence of Kathleen Ryerson's consumption of real water retail bottles.
I'll step down for 1 second.
No problem.
And we're checking right now, so you might not have to produce.
These are the motions received.
Oh, it's right next. Thank you. Thank you, sir, for your patience.
Of course.
Okay.
Is Your Honor okay if I go on to MIL number 12?
Yes, you can, sir.
So, Your Honor, motion limited number 12 from UNFW has to do with some speculative evidence of Kathleen Ryerson's consumption of real water retail bottles. As Your Honor has heard, Kathleen Ryerson was found to be a probable case from the Southern Nevada Health District who drank 5-gallon jugs of real water, and we'll show that to Your Honor here in a few moments. I think some perhaps small portion of this, and I'll defer to Mr. Kemp when he gets up, I think some small portion of this motion may be uncontested, and what Mr. Kemp told us before lunch, at the very least, is that he would stipulate to not claim in front of the jury or infer that Ms. Ryerson ever purchased Whole Foods bottles or real water from Whole Foods.
That's correct.
And Your Honor, there obviously is no evidence of her ever purchasing retail bottles from Whole Foods. You know, one step further, there's actually no evidence of her purchasing retail bottles. So we do think that the jury would try to make a connection with plaintiffs claiming that she may have purchased retail bottles at some point. And so if I could show you the only evidence that's in the case on this, and then you can make the decision. I'm going to show you first, and this comes from two individuals. These are Kathleen Ryerson's two sisters. So first we have Judith Ryerson. Let's show pages, first page 30, lines 9 to 24. So again, Your Honor, this is Judith Ryerson, Ms. Ryerson's sister, and she is specifically asked, you know, if Kathleen Ryerson drank 5-gallon jugs or if she drank, you know, some other form of real water. She explained, and plaintiffs concede in their opposition. I mean, their first heading is titled, and this is page 2 of plaintiff's opposition, decedent was a heavy drinker of real water from 5-gallon jugs. So they concede that she was a heavy drinker of 5-gallon jugs, but there is this kind of suggestion, at least, that she may have purchased a retail bottle once in a while. So Judith Ryerson, page 30, lines 9 through 24, question, okay, what about buying the bottles that are ready to drink that have the real water label? Answer, I only know that she would take a drive every Sunday, go out to Lake Mead, go up to the mountains, you know, just take a drive and listen to reggae music, and she would stop at some place and get bottles of water for her trip. And I found out later from Pat, and that's Pat Sutherland, who I'm going to show you her testimony here in a minute, that they were bottles of real water, but I have no recollection or receipts or anything. Question, okay, did you ever see her have real water delivered in the ready-to-drink smaller bottles? Answer, no, we just had the 5-gallon jugs. Question, okay, do you know how often she would get the 5-gallon jugs delivered? Answer, I think once every 2 weeks. And then, Mr. Stevens, if we could go on to pages 70, line 24, to page 71, line 10 of Judith Ryerson's transcript. So this is in reference to the fact sheet, the plaintiff fact sheet that the two Ryerson sisters, Judith Ryerson and Pat Sutherland, helped fill out for the decedent. And they're asked, question, okay, and then if we go on to page 3, question 2 under section D, is how much real water packaged in retail bottles did you, meaning Kathy, drink on a weekly basis? And the answer was approximately 1 liter sized bottle every week. That was based upon her going for a drive? Answer, yes. Question, okay, and she would get water at a convenience store? Answer, yes. And you're not sure which one? Answer, no, because she'd often gas up at the same time. And finally, for Judith Ryerson, then we'll go over to Pat Sutherland. For Judith Ryerson, if we could show the testimony that is lines 75, or page 75, line 25 to page 76, line 20. And these are shown on plaintiff's opposition, the bottom of page 3 to 4, and I believe that this is what they say supports their ability to tell the jury that she may have drank retail bottles. So, question, you mentioned the Sunday trip she took. Answer, yes. Question, were those every week? Answer, just about, yeah.
Wait, I want to make sure I can follow you. Which line are you on again, sir?
I'm on about line 21 of that page. This is actually, you'll see it when we flip to the next page. This is actually page 75, line 25 to page 76, line 20 of Judith Ryerson's deposition. So question, okay, you mentioned the Sunday trip she took. Answer, yes. Question, were those every week? Answer, just about, yeah. Question, okay, did they vary based on the time of year? Answer, no. Question, okay, and you already said you had no knowledge of where she purchased those bottles. Answer, correct. Question, okay, and I think you said it was only later that you found out from Pat Sutherland, that this was retail water as opposed to any other brand. Answer, yes. Question, what did Pat say? Answer, she just recalled that when the two of them were out sometime together and they would stop and Pat would fill up the car or something, Kathy would say, oh, get me a real water bottle. Question, okay, did you ever see Kathy with a smaller bottle of real water? Answer, no. So, Your Honor, I read that for you because that's what plaintiffs are relying on. And, obviously, we see what it is. It's a suggestion she might have purchased something. And the basis is all from Pat Sutherland. So, for this to be not speculative, we need Pat Sutherland now to agree with this. So let's go over to Pat Sutherland's testimony. So first I'm going to show you Ms. Sutherland's testimony, and this is Exhibit C to our motion limine, page 29, lines 23 to 25. So first she's asked, question, did you ever talk to Kathleen Ryerson about her drinking real water? Answer was once. Okay, now let's go over to page 61, line 20, to page 63, line 18. Okay, question, I'm picking up on line 20 there. You and your sister Kathy were in a car and you stopped at a convenience store and she asked you to go buy real water. Do you recall that? Answer, yes. Question, okay, do you remember approximately when that was? Answer, years, 3 years, possibly longer. Question, so many of us now can separate out things that happened before March 2020 and things that happened after. Do you have any idea whether it was before? Answer, before. Question, okay, so sometime before March 2020, answer, yes. Question, okay, what was the convenience store you stopped at? Answer, I'm sorry, I don't remember. Whoever sold cigarettes, that's why I stopped. Question, was it near your home? Answer, near Kathy's. Question, do you remember what street or what cross streets? Answer, no, I'm sorry. Question, when you went inside, did Kathy stay in the car? Answer, yes. Question, had you ever heard of real water at this point? Answer, no. Question, when Kathy asked you to go get her a bottle of real water, did you know what you were looking for? Answer, not really. I was just expecting to look at labels and choose the one she was requesting. Question, did this store end up having real water in stock? Answer, no, I'm sorry, I can't remember. Question, okay. Answer, I can't remember. And I will keep going. So, and then picking up at line 9, question, so to your knowledge, have you ever seen what a bottle of real water looks like? One that's smaller than the jug that Kathy had in her house? Answer, yes, I would recognize the label. Question, what would you recognize? Answer, it's hard to describe, blue field, there's a number 2 in the reel, in the word, something like that. And then question, and if this store didn't have it, where would you have seen this bottle before? Answer, something in Mr. Kemp's office. So Your Honor, if you look at these two testimonies, I mean, there's the only evidence, I guess if we could call it evidence, of Ms. Ryerson ever actually, I mean, even purchasing a retail bottle of real water, much less consuming it, is the testimony from Judith Ryerson. And she's asked what she bases that on. She says that she bases it entirely on Pat Sutherland. Pat Sutherland says that one time she does remember Kathleen Ryerson, her sister, asking her to go into a convenience store and purchase her a retail bottle of real water. But that the Sutherland cannot remember if she even went in and found the bottle. She couldn't remember if the convenience store even had it. So, you know, based off this, there is no evidence, I mean, admissible evidence, hearsay, or any type of evidence that Ms. Ryerson actually ever purchased or much less consumed a retail bottle of real water. And I'd give you one last piece of evidence, and I previewed this for you the other day, Your Honor, and that's from the Southern Nevada Health District. This is Exhibit 48 to Dr. Zhang's deposition, and this is what the Southern Nevada Health District was able to produce to us when we had the authorization. So if you go to the next page, Mr. Stevens. So again, this is the Southern Nevada Health District's printout of their own internal database. This is from their investigation. The epidemiologist explained that in connection with their case-finding efforts, that they interviewed family members with regard to Ms. Ryerson. It was the two sisters because, you know, she had passed away. On the bottom of page 13, if you would take us there, Mr. Stevens, we have their discussion about what they were told during the questionnaire by Kathleen Ryerson's two sisters. And this is the section that says real water exposure. And you'll see here on the second line, it explains that during the 30 days before the illness onset, approximately how many days did the patient consume real water? So 30 out of 30 days, she consumed real water. Okay, the next sentence. During the 30 days before illness onset, on days when the patient consumed real water, how much water in real water in cups did the patient consume per day on average? Answer was 8 cups. Okay, next question. From which size real water bottles did the patient consume real water? And it says 5-gallon delivery. Next question, did the patient consume any other products from real water, such as the real water concentrate? The answer is no. And, you know, we showed this to the epidemiologist from the Southern Nevada Health District. She explained, yes, you know, this confirms that they told us she drank only the 5-gallon jugs. And, you know, if you look at the last sentence, if she had mentioned any retail bottles, they would have listed that she drank retail bottles. So also based off of what the two sisters told the Southern Nevada Health District, it's completely consistent that she drank only the 5-gallon product of real water. So, Your Honor, I have now showed Your Honor all of the evidence in the case about Ms. Ryerson and, you know, her lack of any purchases of retail bottles of real water. We appreciate, of course, plaintiffs' agreement that they will stipulate that they will not infer in any way that she ever purchased any retail bottles from Whole Foods. However, we do not believe that that is enough. Obviously, Your Honor sees the impact of Ms. Ryerson. She is the one actual outbreak case from the Southern Nevada Health District that's in this case before Your Honor. She's the one single one. All the others are these kind of tack-on cases, for lack of a better word, that were not outbreak cases, and, you know, essentially we're not even investigating, we're never deemed probable nor suspect cases. If plaintiffs, who by their own admission state that Ms. Ryerson was a heavy drinker of real water from 5-gallon jugs from the home and office delivery, if they're able to even infer that she also consumed the retail bottles, despite the lack of any admissible evidence on that point, that will unduly prejudice the defendants in this case, particularly UNFW, since it is the main distributor or retailer in this litigation. So, Your Honor, based off that, we would ask that Ms. Ryerson's alleged retail bottle purchases or purchase would be excluded. There is no admissible evidence. Everything to suggest that she ever did have a retail bottle purchase is speculative, and there is no evidence before Your Honor to support that.
Thank you, sir.
Thank you.